every detail was something to talk about or something the fans would have a big opinion about. But that was also exciting to me, and I took that on as a challenge because I was making this for them. So I wanted to know. Early on in the process, as soon as we had our first draft of a finished script, I asked Colleen if it was okay, if she would come out to LA, and we brought out like 13 or 12 super fans, and we did a reading of the script together. And I got so much information out of that, and it really helped me understand the mind of the reader.
Hey besties, buckle up because this one's wild. Blake Lively is catching serious heat from Wayfair's attorneys after demanding that executive Jimmy Heath turn over personal home videos. Yes, even the footage of his wife's labor. According to Wayfair, those videos were never shared with Blake in any capacity, yet she's accusing Heath of defying a court order by refusing to hand them over. The audacity level? Off the charts. Now Blake isn't just making demands, she's going nuclear. She's asking the court for the most extreme sanctions against Jimmy Heath, claiming he deliberately withheld those home videos. If that sounds invasive, that's because it is. Last week, we unpacked how this motion wasn't just about evidence, it was about humiliation. Blake's legal team essentially tried to drag Natasha Heath, Jaime's wife, into the spotlight by targeting an incredibly private, vulnerable moment, the birth of her daughter. Blake insists that Jaime's testimony somehow proves he hid the footage, even though her filings are conveniently blacked out in all the key places. And here's where things really start to unravel. Turns out, the parts Blake blacked out in her motion, Wayfair's attorneys filled in the blanks. And the testimony she claimed proved her case isn't even close to what she made it sound like. What's actually on record paints a very different picture. One that looks a lot more like Blake playing procedural chess than uncovering any truth. Now, I can't predict how the court will rule, but one thing's clear, Judge Ellen Gaff has had enough. Sources say she came down hard on Blake's tactics, and the tone in her latest remarks suggests her patience is officially running out. In her fiery response letter, Judge Ellen Gaff didn't mince words. Wayfair's attorneys blasted Blake's request as draconian sanctions, the legal equivalent of saying, "You've completely lost the plot." They argued that Blake's motion doesn't even meet the basic threshold under Rule 37B, the rule that governs serious sanctions when someone violates a clear court order. And here's the catch. For Rule 37B to apply, there actually has to be a violated court order. According to Wayfair, there isn't one. No directive ignored, no evidence destroyed. Just another overblown accusation wrapped in outrage. For Blake's motion to stick, she needs to prove two key things under Rule 37B. That Jaime Heath violated a clear court order, and that his non-compliance was willful, meaning deliberate or done in bad faith. That rule exists for one reason: to punish parties who flat-out ignore discovery orders, like refusing to hand over evidence the court specifically told them to produce. But here's the problem. Blake's argument hinges on the claim that Heath was ordered to turn over those home videos. Wayfair's team says that's simply not true. No such order ever existed. In other words, Blake's entire motion may be built on sand. Wayfair's response argues that they have already complied with all discovery obligations, and that Lively's motion fails on multiple grounds. According to their filing, two fatal flaws undermine her argument entirely. First, they claim Lively never actually requested the footage during the discovery phase, and the deadline for doing so has long passed. Second, they insist there was never any clear or unambiguous court order requiring them to produce the complete birthing videos. The prior order, they emphasize, merely directed the parties to meet and confer on specific production issues, not to turn over the entire set of recordings. In essence, Wayfair's counsel is asserting that Lively's motion to compel rests on a mischaracterization of both the procedural history and the court's previous directives. They argue that she is attempting to retroactively expand discovery obligations that never existed, framing her demand as both untimely and unsupported by any enforceable order. Wayfair's counsel further clarifies that the court's prior order did not mandate the production of all birthing footage, but rather only the specific material referenced in Lively's request for production, number 108, Ref P 108. That request sought documents and video evidence directly related to paragraph 101 of Wayfair's SDNY complaint, the portion, alleging that Lively falsely claimed she was shown pornographic or nude images of Heath's wife on set. In other words, Wayfair argues that the order was limited in scope and intended only to address that single claim of alleged misrepresentation. They maintain that no broader obligation was imposed, and that they have already complied by producing what was responsive to RFP 108. Nothing more, nothing less. In turn, paragraph 101 of Wayfair's SDNY complaint specifies that what Lively actually viewed was a single still frame at the beginning of the video, an image depicting Heath's wife, Heath himself, and their newborn child immediately after a home birth. The footage, they emphasize, merely captured a natural, post-delivery moment within the context of a private family recording. Wayfair asserts that Lively grossly mischaracterized this image by publicly implying she had been shown pornographic or unclothed material of Heath's wife on set. According to their statement, the video in question was a deeply personal but non-explicit depiction of childbirth, and her suggestion that it was indecent or inappropriate was not only false but maliciously framed to damage reputations. The video, which included the newborn, was recorded immediately after the birth. Lively's pleadings claim that Keith began playing a video depicting a fully unclothed woman with her legs spread apart. Wayfair maintains that this description is not inconsistent with the post-delivery video actually shown to Lively. In fact, that very footage was produced on August 22, 2025, well before the court issued any order. Lively now belatedly contends that this was not the video she viewed from Heath. Yet, despite having repeatedly described in varying ways what she allegedly saw in May 2023, she did not object at the time that the August 22nd production failed to include the video she claims to have seen, as specifically requested in RFP number 108. Wayfair stresses that, even if Lively believed that RFP 108 covered all videos related to the birth, it did not. The request was limited in scope, and Wayfair has already complied fully with its obligations under that production request. Lively did not raise any objection until September 24, 2025, claiming that the video produced was not the one she had viewed. Even then, she failed to timely file a motion to compel production of additional footage before the discovery deadline had passed. Wayfair emphasizes that this delay further undermines her argument, as the window for raising such issues had long closed, and the production made on August 22nd fully satisfied the scope of RFP number 108. The discovery period for fact evidence closed on September 30th, 2025, to the extent that Lively's sanctions motion is really just a thinly veiled, untimely motion to compel. Wayfair argues it should be denied. Ultimately, much of the dispute appears to stem from the fact that Lively did not receive exactly what she hoped for, rather than any genuine failure by Wayfair to comply with its discovery obligations. Wayfair emphasizes that Lively's complaint essentially boils down to dissatisfaction with what was produced, rather than any failure to comply with discovery. She seeks a video that matches her quote-unquote memory, yet the footage provided on August 22, 2025, fully satisfied RFP number 108. Lively, however, waited more than a month to assert that the video did not match what she recalled seeing. This delay, Wayfair notes, highlights the speculative and subjective nature of her claim, rather than any actual non-compliance or misconduct on their part. Wayfair points out that memories can change over time, and Lively is now, 2 years later, asserting that the video produced was not what she saw. Throughout the entirety of the Wayfair lawsuit, she never denied having viewed the footage in question. She also did not deny that discussions about a birth video occurred. The video at issue depicted a birthing scene that she had previously acknowledged, making her current claim appear retrospective and inconsistent with her earlier statements. The footage in question depicted a birthing scene that Lively was going to participate in as part of the film's creative vision. Wayfair emphasizes that it is just wild that Lively is now attempting to reconstruct events to fit her narrative, despite there being no evidence to support her claim. She cannot succeed because the specific material she seeks simply does not exist. Lively now argues that she should be permitted to scrutinize highly intimate and personal footage to locate segments that align with her account, that she was shown explicit content. Wayfair counters that such a request is unwarranted, invasive, and beyond the scope of any legitimate discovery obligation, further underscoring that her motion is more about attempting to manufacture evidence than remedying any real deficiency. Lively claims she was shown footage of the actual birth, when in reality, she was not. Wayfair emphasizes that intruding into the highly sensitive moments of a woman's labor and delivery cannot be justified simply because Lively believes she might find material that supports her account. In short, Lively fails to demonstrate any entitlement to private. And intimate footage of Natasha Heath during labor and childbirth. This is particularly significant given that Lively never previously objected to the footage produced in response to RFP number 108 and only raised her claim long after the discovery window had closed. Wayfair stresses that the only footage requested in RFP number 108 was the short video showing Heath, his wife, and their newborn immediately after the birth. Lively did not seek clarification on the scope of the court's order. Instead, consistent with her pattern in this case, she asks the court to immediately impose the most severe sanction available, bypassing any discussion or consideration of the actual production provided and the limited scope of the discovery request. Lively also seeks an order precluding evidence that is relevant to Heath's defense against her sexual harassment claim. Wayfair points out that this motion is merely one in a series of sanctions requests in which Lively, facing the reality that discovery did not produce evidence supporting her allegations, attempts to obtain an adverse inference or preclusion order. Such relief, she hopes, would effectively shift the burden and relieve her of proving her claims, rather than addressing any genuine discovery deficiency. Essentially, Lively is attempting to avoid the burden of proving her claims by seeking to eliminate evidence favorable to the defense. Observers have noted that Wayfair could have taken a direct approach in responding to the cascade of sanctions motions, and this particular motion appears to be the clearest example of her strategy. In essence, Lively is pursuing sanctions not to remedy a discovery issue, but rather as a tactical effort to gain an advantage in the case by prejudicing the defense. Wayfair argues that Lively is pursuing this course because she cannot substantiate her claims, the only conceivable reason to request an adverse inference, which would instruct the court to assume that missing or withheld evidence is unfavorable to the defense would be to compensate for her inability to prove her case through actual evidence. This tactic, Wayfair contends, underscores that her motion is strategic rather than justified, aimed at creating a legal shortcut rather than addressing any legitimate discovery deficiency. Wayfair points out that Jaime cannot deny that this was the video shown to Lively, and he cannot dispute her recollection. Yet, by seeking to exclude this evidence, Lively is effectively removing his opportunity to testify and provide relevant facts. Because the footage does not support her narrative, she apparently seeks to pretend it is something else in order to bolster her position. Observers have noted the extraordinary mental gymnastics at play here. While the focus is on Lively, it is her attorneys driving much of this strategy. Normally, lawyers would advise a client against pursuing baseless claims when evidence is lacking. Yet in this case, her counsel appears willing to incur massive expenses and pursue every questionable tactic, allowing Lively to chase sanctions and claims, with little regard for the actual evidentiary record. Wayfair argues that Lively's conduct throughout this litigation reflects delusional beliefs about the company and its employees, and a disturbing pattern of behavior aimed at invading privacy and exploiting other women involved in the case. The extent of this, they note, is astronomical. Lively has allegedly sought to harm Natasha Heath, Emily Baldoni, Jen Isle, Melissa Nathan, Brianna Coslow, and Katie Cassis, all women connected to the proceedings in some capacity. Wayfair's counsel stresses that the court's prior order did not direct the defendants to produce all videos of Natasha Heath giving birth. Rather, the order was narrowly tailored, limited to the specific segment referenced in RFP number 108, which concerned only the brief clip showing Heath, his wife, and their newborn immediately after delivery. The court's prior order directed Heath to produce the video sought by RFP number 108, as described in paragraph 101 of the complaint. However, Lively now claims that she learned at Heath's October 8th deposition that additional, more extensive videos exist. Even if this is true, Wayfair stresses that it does not alter the scope of the court's order, which applied only to the video specifically identified in RFP number 108 and paragraph 101. Essentially, Lively is attempting to suggest that Heath lied about what was produced, even though she never requested all footage of the birth in discovery. Her RFPs explicitly sought the short video that Heath provided, and that is exactly what was produced. Notably, Lively did not independently pursue discovery for other footage on her own, which she could have done to support her claims, but chose not to. At his deposition, Heath confirmed that the video shown to Lively and produced in the case was complete for the purposes of RFP number 108. It was not an altered excerpt of a longer video capturing the full labor and birth. The longer, more intimate videos were separate and distinct, recorded after the birth of his daughter, and were kept private on Heath's phone out of concern they might fall into the wrong hands. In short, there is no court order requiring Heath to produce all birth footage, only the post-delivery video of his daughter shown to Lively. Footnotes indicate that Heath stores videos of both children's births on the same thumb drive, but Lively does not clarify whether she seeks the entirety of both births' footage to search for anything that might fit her narrative. There has never been a dispute that the